Hello and welcome to the first series of monthly webinars organized by Young Members Group of MCA Academy for International Legal Studies, or MCA YMG. My name is Nia and I'm a project leader of MCA YMG. MCA Academy, our parent, is a non-for-profit organization that offers training and research programs in the areas of international dispute resolution, energy law, banking and finance, legal tech, and women empowerment. At MCA Academy's Young Members Group, we have created a unique platform for exchange of knowledge, ideas, information, and experience for students and young professionals under the age of 35 who are passionate about our areas of expertise. It is free, and our activities include monthly webinars, training sessions, and networking events. We also offer our members discounts and free seats for the activities organized by MCA Academy. Our mission is to share our experience and contribute to a continuous self-development. Offering your training and learning tools, we truly believe that each of you can make a meaningful change on a personal, educational, and more global level. If you want to become our member or learn more about what we do, please visit our website. The details will be under this video. Today's webinar is dedicated to careers in international dispute resolution, and we are glad to present to you two of our speakers, Mr. James Cockburn and Mr. Ben Wells, who are experienced dispute resolution lawyers. They will talk about their personal career path. Following that, we will have a question and answer session and a discussion. We also have on our panel Olga, Edward, and Kumudini, who are going to voice concerns of the students and young professionals pursuing careers in international disputes. Okay, let's start with our first speaker, James. Until recently, a senior associate at the London office, Melly Prevost, Holt and Mosley, and now moving to Kings and Spalding's London office. James focuses his practice on investor state and international commercial arbitration, as well as commercial litigation. He has advised on a wide range of complex and high-profile cases in the area of oil and gas, natural resources, banking, construction, and telecommunication. James, please.
Hello, Nia.
Hello.
Hi, thank you for introducing me. Yes, so my name's James Cockburn. I'm a senior associate, so I've been working in disputes for about 10 years in the London market and also in the Middle East. I worked in Dubai, and I'm qualified both in the courts of England and Wales and the DIFC courts in Dubai. So my personal career path started off a little unconventional. I qualified at a middle-tier English firm, and I wasn't really doing disputes at that time. I thought I might want to be a more public sector lawyer. And then I got a taste for disputes and realized that's what I wanted to do. And so I left that firm. The last 7 years trying to find the right firm for me with the right mix of work, and I've been at Curtis Mallet for the past 4 years, which has been a great experience, a fantastic introduction to, in particular, investor state disputes, because Curtis is one of the world's foremost arbitration firms, particularly representing states. So what I've really been doing there is working for, alongside big teams across offices at Curtis, and there are maybe 20, I think 15 to 20 offices, and I worked almost every day with people at every single one of those offices. And we acted for the states in investor state disputes. For those who don't know what that is where a private commercial enterprise has taken a risk and invested money, expertise, and time in another jurisdiction. For example, in natural resources, that often means going and building a power station or an oil refinery or such like. And they fall out at some point, and then arbitration lawyers are brought in to resolve a dispute between the country, which the company feels it has mistreated it, and the self. And we act generally for the country. It's hugely challenging. There are unique challenges working for states, but it's very fulfilling at the same time. I'd say the main thing that Curtis lawyers have to deal with is the fact that a dispute is never purely a legal dispute. When you act for a state, it's always a political dispute as well. So we have to manage the legal side of things, the factual side of things, and the political side of things all at the same time. So in a sense, the way I came to arbitration was accidentally. And I started off as a litigator, but arbitration, in particular, international arbitration at big firms in London, is so prevalent that it's difficult to avoid, if I'm honest. And so I ended up doing more and more arbitration and enjoying it more and more, and then developing that as my focus. I still keep litigation very much as my second practice. It's not really that different. For a senior disputes lawyer, there are a lot of very, very similar things about litigation, but I enjoy also working in the London courts as well as in international tribunals. I like arbitration in particular and disputes in general because there's never a dull moment. It's always contentious by nature, therefore it keeps you on your toes, and you have to be inventive. I have more of a creative background before I went into law, and so it satisfies that part of me that wants to do more creative thinking. And because there's 100, 200 ways a dispute could go, you as a senior disputes lawyer are choosing which way this dispute will go to some extent, and that is a creative process, and that's what I enjoy. It's challenging in that, especially when you're working with international clients, the hours are long. I've had long periods where I've worked with New York at the same time as working with Dubai, which means my day starts 6 a.m. my time and finishes 11, 12 p.m. my time. I try and manage that as best I can, but often you can't do anything but just work very long hours. And because it's contentious, if you're susceptible to pressure and you feel tension badly, then that can impact on you, because you're constantly in a fight, you're constantly in the back foot and being defensive a lot of the time, particularly when you work with states, because you're always a defense lawyer then. And you're being attacked all the time, and so that can be challenging. In terms of what it's like day to day, a lot of what I do in arbitration is really formulating arguments, because the cases that I've worked on are very high value, very often more than 100 million, sometimes several $billion disputes. You get a long time, a lot of focus is placed on making sure you refine every aspect of your argument. And so we spend months researching effectively and writing briefs, preparing for the next brief. Managing the client is another huge part of it. So, we have to manage their expectations. We have to encourage them to give us input and give us instructions, which is not always a simple process. And then, of course, we come to hearings, which form a relatively large part of my year, although less than they would for a lawyer working on smaller scale disputes more frequently. So yeah, you have office work, research, you have going out and speaking to clients, which is a large part of it, and then you have going to tribunals and courts, And that's generally the spread of my work. On the litigation side, a lot of time is also spent working alongside counsel, because still in London, you often have to brief counsel, and so we work across with barristers and occasionally other law firms as well. My typical day, because I'm at an American law firm, I've often worked late, and so my typical day doesn't necessarily start at 9 AM, but I will go to the office, take a moment, and then I will pick up where I left off the day before, effectively. I'm usually in the middle of a thought process. When I was a more junior lawyer, I used to find it a little bit disconcerting because I felt like I didn't achieve much in a day. And then as I get more senior, I realized that when you're working on complex disputes, often you don't feel like you've achieved anything, but you have thought about it, you have processed it, and then at the end of the day, you're a little bit further ahead in terms of understanding the complex background and understanding the complex legal arguments you're going to make. And a useful skill is to relax about not necessarily writing a lot or reading a lot in a day, but actually thinking about things. And then typically I will be on the phone a large part of the day speaking to lawyers in other Curtis offices and external counsel and the client. And we use Skype a lot of the time as well to communicate. So I have a lot of FaceTime with people in other countries every day. I suppose finally, just to wrap this up, I have actually exclusively done international work since I qualified as a solicitor. I've never done a dispute between two English or UK parties, and almost always there's no UK party involved in it at all. And so I have travelled and I have come across other places. I should have mentioned the kind of areas we work with are Central Asia, Africa, South America a lot. And so I've spent a lot of time getting to know, and the Middle East, those jurisdictions. And I've spent time in all of those jurisdictions. And I've benefited from just understanding how people think both differently and similarly in other places. And then, the main benefit from Curtis is understanding how to deal with something like a state, which is a mammoth organization, which has completely different priorities often and perspectives on things than a company might do. And so that's been enormously beneficial to me. And I very much enjoy it, and I will be moving to another firm with a bit of regret because Curtis is a great firm, but King & Spalding is also a fantastic firm, so I'm looking forward to that in January. And I'm a little informal because I'm on paternity leave right now. There you go.
So, Nia, thank you very much for having me here.
Thank you very much, James.
James, congratulations. Fantastic news.
Thank you.
And just to run you through a bit about my career and how I started off, I am a solicitor working at a firm called Shepherd and Wedderburn in London. I am qualified in England and Wales, and I have 3 years post-qualification experience. My practice is split between commercial litigation and arbitration, and I would say that I probably do a bit more litigation than arbitration at present, but it's quite a varied workload, which is nice because it keeps things interesting. In terms of starting out, I got my first legal experience working in Moscow as a paralegal, and was actually at a French law firm there, which was very close to the Red Square. And it turns out the predominant amount of lawyers were Russian and Russian speakers, but lots of the documentation was in English. Being the only native English speaker there was fantastic because I got a chance to work in all different departments throughout the firm. And I was there for around 2 years before coming back to London to do my LPC, which many of you know is the legal practice course, and it's the second higher level of education that you do after your law degree to become a solicitor in England and Wales. There's also another option whereby if you haven't done a straight law degree, you can do, which is the graduate diploma in law, and do the LPC and to become a solicitor. Part of the solicitor process is that you need to do a training contract, and I got my training contract and finished it at CMS Cameron McKenna, which is a silver circle here firm in the United Kingdom and with offices all around the world as well. During the process, where sometimes it takes up to 2 years to start that traineeship from getting it, and during that time I had a great opportunity to work also as a paralegal. I worked at Freshfields on some really interesting, very multinational cases. One was to do with insider trading at a big American bank, and another one was with regards to the illegal flaring of gas in one of Kazakhstan's largest oil fields. And having my Russian language experience enabled me to review court judgments from Kazakhstan which were in Russian and then report back to the client on those issues. Following on from that, still had some time before I started my traineeship, and I worked on a case with a Kazakh oligarch who had been accused of embezzling a very large sum of money. And again, it was really good experience, and it really gave me a taste of the flavour for disputes, the type of interaction you can get on those cases. For example, for that case, I sat in on meetings with this oligarch and found out a bit more about his predicament, what was going on, and really thought about how we could best structure his claim. Overall, disputes can be very varied, and in the lead up, just before I started my traineeship, I worked at the Financial Ombudsman Service on banking and insurance claims, generally for the general public who had made complaints against these big institutes and organisations. And that again was fantastic to be able to communicate with all of these different parties on the telephone and in writing to really make things as clear as possible. And as an adjudicator there, you would reach a final decision. Obviously, if that was disputed anyway, then it would go through to the Ombudsman, who we spoke to on a regular basis as well. While the remit there is not specifically legal, they do have a very legal process and procedure that is very applicable to disputes and to the law. So I found myself in good stead. Although I didn't go directly into my traineeship, I found that I had got together some good experience, which really helped me for when I did start. Following on from that, so I really knew I wanted to do disputes after the cases that I had already worked on, and seeing how interesting it was and the breadth of experience that I had gained. Following my traineeship, I went to Linkley on a very large case which regarding the $1 billion to a very wealthy Saudi family. And then I went on to work on another case in the High Court, which was a $2.1 billion claim by a country against some financial institutions. So I suppose similar to the kind of cases that James has been working on. After that, I started at my current position, which is at Shepherd and Wedderburn, and here I am heading up the Russian offering. So it means speaking with clients from Russia and the CIS, so all of the former CSSR countries on a regular basis. And I'm really enjoying developing the practice here, while at the same time gaining additional experience in dispute resolution and also in arbitration. I suppose it can be challenging in this industry, especially with the hours that do come over multiple time zones, especially when working or going to Kazakhstan for meetings or for seminars. It certainly can put a lot of stress on you when you're trying to deal with everything in the most expedient and best way for your clients. In general, my typical day can be extremely varied. If I'm in court that day, then it's predominantly prepping for the particular case, and then going to court to support counsel. We will usually instruct a barrister to represent the clients in the court, and so your whole day can be taken up by that very easily. Also, being generally interacting with clients, prepping for meetings with clients and speaking to them, whether it be face-to-face or by telephone, and generally prepping correspondence on a case, so from side to side, and structuring your client's arguments. Very often it will be in the form of both open and without prejudice letters, so really structuring your client's argument as best you can while being mindful of costs and ensuring that they are not left open to adverse costs orders if at all possible. In terms of my career to date, I definitely think that my international experience has really helped me without a doubt. It's definitely enabled me to find my first positions in London, having that experience in Moscow, and also having Russian as a second language has been particularly helpful. And in terms of going forward in people's careers, I think it's very important to stick with your ambitions and your dreams, and to keep going with any applications, or especially conferences and seminars such as this one are particularly invaluable, especially if you can speak to people in the industry, get to find out a bit more about how they have gone down their career path, or potentially if you can find in a similar view a mentor. I personally work as a mentor for students at Westminster University and really help them through the application process, obviously based here in England and Wales, and help them to try and structure their applications and to prepare for their interviews in the best way possible.
Thank you very much, Ben. That was very useful, and I'm sure that all of our members will appreciate what you told us. And thank you very much, James. We are now opening our question and answer session. One of our missions at the Young Members Group is to make sure that students' opinions and concerns are heard. Therefore, we have invited Olga, who is an international student, currently undertaking an LLM program at Cambridge University. Olga holds an LLB from Maastricht University and has participated in William V's International Commercial Arbitration Moot. Did a short survey at her university to see what are the main concerns of students looking for careers in international disputes. Olga, please start asking your questions.
All right. Thank you very much, Nia, for the introduction. I hope you can all hear me well. As you mentioned, I did make a little survey among my peers and friends, and I've narrowed down some questions to ask to Ben, James, but essentially anyone who wants to contribute. I think me and my friends are very anxious about our careers in the future, and it goes for all the fields of law, dispute resolution, or any other fields. For me, my concerns are particularly centered around dispute resolution because this is what I want to do. So, right, to start, first, a very general question. What is a typical path to establish a career in dispute resolution?
James or Ben, who would like to start?
I'm happy to take that to begin with. Can you hear me?
Yeah.
Yes, sure.
So, I mean, the thing I would say is a bit of a trick answer. If you're qualifying as a UK a solicitor, and I can't say how it works elsewhere. What I often say to people is it's best not to focus too much on what you would like to do. Having very specific goals is problematic. And the nature of a training contract in this country is you will do a dispute seat, maybe two, and you will also do other kinds of seats. And the best trainees are the ones with an open mind about what they may eventually like to do. Those who are determined to, I meet people who say, I really want to do international arbitration in an American law firm, and they're still in school or in their first year of university. I say to them, I don't think that's the right approach. You don't know what will interest you. For example, I didn't intend to be a dispute lawyer, but the thing that I decided I wanted to do just didn't really interest me, and this did instead. So, keep an open mind. On the other hand, if you do, then international experience is key if that's the kind of dispute work that you want to do. So, work in other countries and talk to people from other countries. Just keep your network broad and your ears open, and that's the kind of international commercial knowledge you can gain for yourself, which will benefit you hugely in a career.
Yes, I definitely second what James said without a shadow of doubt, because especially with the trainee system here in the United Kingdom, it's very likely that you'll have to do 4 seats, potentially sometimes 6, and they will be in very varied areas. And actually where you qualify into has a lot of dependence on the business need of the firm at the time and where they require people to be seated. So it's very important to come with an open mind. I think all law firms will really appreciate that. However, if you are completely set on disputes, then if you pick a firm dominance of disputes as its main practice, then of course that would be really helpful, because you're more likely to then fall into one of those dispute seats upon qualification.
And actually, I'd add one more thing to that, just to sort of give you an example. A trainee in the UK who is intent on doing a corporate seat or a dispute seat, if they're too focused, they can give a bad impression to the lawyers working in the department they're not interested in. And you can be sure that that feedback and that impression will be given to those lawyers in the department you are interested in, and it will not work in your favor. So you have to throw yourself at everything that you do 100%, and don't make it too clear if you're not interested. Don't make that obvious at all. Just be interested in everything. And if you do a corporate seat, you will find there's knowledge you gain there which will be useful in your disputes role or your disputes seat. So nothing is irrelevant and nothing is pointless. So take everything, by the neck, effectively.
All right.
Working banking and property, that will also be very useful to each other. And overall, you might find that you, in fact, really like one of those other seats more than you thought you might like to speak. So I suppose an open mind.
All right. Then back to me for a while. Thank you very much for your answers. I wanted to ask a specific question to you, Ben, actually, because you mentioned that you were a paralegal before starting a training contract, and I wanted to ask if you would recommend working as a paralegal or doing a similar job before attempting to obtain a training contract.
Oh, definitely. I think that would be a very good source of experience. And even if not working as a trainee, there are several opportunities to work in law firms, such as summer placements where you could volunteer, or if not, the vacation scheme system, which you might have heard of, which involves working in a law firm for either 1 or 2 weeks during the summer period. And actually that involves usually an interview at the end of the week where it's possible for you to get a training contract. So either of those, or working as a paralegal even just from the side of things that you get to know the systems and you're able to use file sites successfully to be able to save things down and print. I mean, that's all the big challenge of starting at a law firm, that if you can get your head around in advance, will give you an advantage when starting there.
All right. Thank you very much. And another question that I have is again about career paths and how to establish a career in dispute resolution, but also in other fields. As we mentioned before, we should keep an open mind to other fields as well. Is it possible to establish a career in dispute resolution or in a big law firm as a non-qualified lawyer, or as a person with a non-legal background? And how would that work?
It depends what you mean exactly. Do you mean as a practicing lawyer?
Perhaps, but not necessarily. It could also mean like how a non-qualified person establishes himself or herself in a law firm in any way.
Right. Well, I mean, apart from lawyers, there are limited roles within law firms. Lawyers and paralegals, secretaries, and people in finance and people in marketing. I assume you're not talking about going into marketing or accounts. So if you mean someone who doesn't do the university law course, in the UK, that's very easy. I didn't do law at university. I did the conversion course. And so, you know, I actually did art history and Italian at university. And then it's easy to become a lawyer, as easy to become a lawyer as it is for a law graduate, I think. And nowadays, there's a broad mix of people from law and non-law backgrounds. But ultimately, if you want to be a lawyer, you have to have qualified as a lawyer somewhere. And you can only do that having studied law to some degree. There is a route in the UK where you never formally, I don't think you ever formally attend a law course. You have to work for a long time, and then I think maybe there are some extra classes you do, but you don't go to university. And that's not a route I would recommend at the moment because it's very untested, and big firms are not interested. There are so many law graduates and people who've done conversion courses that they aren't, you know, it's not worth their time at the moment, I would say, investing the risk of those other paths. I think it's called ILEX, but you should look it up anyway. And another thing to note, if you're talking about whether you can establish a career, say in the UK, without having got a UK qualification, then definitely you can. I work with people who are not qualified in this country all the time. And the offices I've worked in the last 10 years have got people from all over the world. You can practice in international arbitration, this is key, really with a legal qualification from anywhere. You know, you don't have to be an English qualified lawyer to work on arbitration disputes in England, because the arbitrations aren't really anything to do with England. We're just geographically located there, and often the language is English. So I think that answers your question. But ultimately, you're going to have to get a qualification from somewhere.
Right. Yeah, that indeed answers my question. But it made me think of something else as well. So do you, Ben, James, anyone, do you think that Brexit would influence the situation of non-British qualified lawyers working in the UK?
So with regard to working in the terms of EU citizens, it would have been very straightforward. It currently is very straightforward for them to work in the United Kingdom. Certainly after Brexit, we're not currently sure of the situation that's going to be in play at that time, and it could be difficult at that time. So it's definitely a space to watch to see what the final outcome will be.
Yeah, I agree, but I'm strongly convinced that they will make something work. so that we don't lose all our international lawyers, because it's too valuable a business, particularly in London, for that politically. It would be a nightmare. It would be like losing all our bankers. I just don't think the government will let that happen. But watch this space.
Yes, I mean, I pretty much really hope that the situation wouldn't change that much, because then that would mean for me to go back to wherever I'm from, and I don't really want to do that yet. So another question that was mentioned by my friends was, what are the characteristics important for a trainee candidate to work in a dispute resolution, but also in other fields? Is there anything that you could name as the personal qualities to have?
Sure, I can start that one. It's very subjective. For me, the best quality I see in someone is, there's only one way to put it, is being switched on. You don't have to be the most knowledgeable, you don't have to be the brightest, you have to be switched on at all times, or at least you have to appear switched on. So what that is really engaging with people, being open to people, and having an open mind. Sorry if this sounds a bit vague, but the point is that I've worked with some extremely bright people who were not very helpful, and I've worked with other people who are very hardworking and very driven, who maybe didn't have the top qualifications and weren't off the charts intelligence-wise, but were extremely effective lawyers. And so please just remember that personal skills are almost more important than any other skill in this profession. And I think that's really what I mean. Interpersonal skills are #1 priority for me when I'm working with junior lawyers.
If I may add, I would say without a shadow of a doubt, someone who is enthusiastic and dedicated and really willing to go that extra mile, and who is there at hand to assist you when you need it, that will speak absolute volumes.
If I may add something, we have Edward on our panel, and Edward is the president of LCM Student Association here in Belgium. Edward is specializing in training students to negotiate and mediate. So maybe Edward has anything to add to that? What skills are necessary to to kickstart your career in disputes?
Thank you, Nia. To give a better view of what LCM SA does, we really give training to an interfaculty group of students here at the University of Leuven. So from our point of view, a particular background like being a lawyer or being an economist or a doctor is merely a bias more than really a professional requirement, as I understood from James. So my question is, for those big law firms, is there in any way a future for non-lawyers to become accredited negotiators or mediators or anything that has to do with ADR as well? Because from our point of view, what we really teach is the techniques themselves, so the empathic listening, the active listening, how to come back to objective criteria, how to ask for interests instead of positions, etc., etc. Do you think there is a future, or that is a threshold for the art of being a negotiator or mediator?
That's a really good, interesting question. I know that some law firms have a broad practice that encompasses things like forensic accountancy and investigations, for example, which can be carried out by non-lawyers. And they're very exciting places, and I think there is a big future in that kind of firm, and there is definitely a role for non-lawyers in these kinds of strategic matters. But the lawyers will always be the most important people in a dispute ultimately, and that's always going to be the case. But you know, pre-dispute, there's a lot of work that's done by other people. That's for sure. Law firms in London that I see are bringing in expertise rather than outsourcing all the time. And so, you know, I probably shouldn't name competition, but there are firms out there that have a broad roster of different kinds of professions working together. You just have to find them.
Thank you for that answer. And maybe a little small follow-up question. Is there in the UK, there is a regulation in Belgium here, but is there in the UK also a requirement to have a specific certificate or accreditation to also practice as a mediator?
I'm not aware of that here. The thing that would be difficult is, in order to give legal advice, you should be legally qualified. It'd be difficult in a sense. Maybe as a mediator, you don't have to give legal advice. So I'm going to exercise one of the skills of litigation solicitor and say, actually, I don't know the answer to that question. I'm not going to pretend I do.
Okay, thank you, James. Olga, you can continue with your questions, or if there are no questions, we can start with questions that were sent to us by young members group members.
Okay, there is one other question that was mentioned to me by my peers and that I'm also interested in. It's said many times that commercial lawyers have to, or lawyers in these big law firms in London, they have to exercise commercial awareness, and that is the quality that everyone is looking for. And I wanted to ask Ben and James, how do you keep up to date with what is happening in the world, and how do you keep up to date with new developments in your field?
Thank you, Olga. That's a really good question, and it is something that you definitely have to keep abreast of, and it's not something that you can do instantaneously. It's something that you have to work at over a long period of time. So reading publications, I don't know, for example, something like The Economist, which has a very wide range of issues that you can really get to grips with. I think that having that particular background, start to focus on the issues individually, really helps. In terms of keeping up to date once in your industry, then there are a lot of seminars and conferences that you can attend, and there are always the new cases being discussed, which are the ones that you should always keep up to date with and be aware of, so that more than anything, if one of those issues should arise with a case that your client is involved in, that you will know to go and look that up and find out additional information that may be important.
Right, thank you. I don't know if you, James, have anything to add to this.
No, I think that's pretty much what I was going to say. I think this is a term that stresses out students enormously. I've done a couple of, I do a few student events like this, and it's the same question people always ask. I think, kind of as Ben was saying, is actually commercial awareness doesn't mean commercial knowledge. You don't have to know everything that's happening. You have to be interested in the commercial world, and that interest is gained through reading and through speaking to people and through doing work experience within companies, for example. But no one expects you to know the latest mergers and acquisitions that have happened, for example. But you know, it's very clear when a student or a young lawyer is commercially astute, let's say. because they will have a feel for what it is that business people want and what they mean when they talk, and that's something you gain from, like I say, work experience. And a key thing for commercial litigators is you need to be able to identify with your client, and if that client is a company, you need to be able to speak the same language as them, and you need to understand how their minds work. And again, that's not all specific knowledge. It's more just being able to put yourself in the mindset of a business person.
Okay. Right. Thank you both. I think that concludes the bundle of questions that I've collected. So Nia, if there is anything else that you want to ask on behalf of the Young Members Group.
Thank you very much, Olga. Are there any questions or comments from the panel? We have a Young Members Group member, Kumudini, here, or maybe Edward, Adnan. If there are no comments, we are going to go through the questions that we have received at the Young Members Group from our members who are students and young professionals.
Yeah, so can you hear me?
Yes, Kumudini, please.
Yeah, so hi, I was willing to ask the panel some questions that I had. Now, for foreign qualified lawyers like us, like somebody like me who's already had an experience of 4 years in international arbitration in Dubai, and now I'm doing my LLM in Queen Mary in international arbitration, what should be the career path if I wish to establish myself in London? Now, I understand training contracts are typically meant for students who have just graduated, and there are internship roles available in some law firms, but I mean, so typically an internship program is probably what best suits us, because a training contract or a WAC scheme is typically formulated for people who've just graduated out of law school. So is my understanding correct, or I just basically wish to understand what the panelists have to say about this for a person like me who's already has had an experience in arbitration?
Yeah.
Hello?
Oh, hi. Can I give you my thoughts in the first instance?
Sure, go ahead, please. I'm looking forward to it.
So definitely what you're saying with regard to vacation schemes, I think that firms do take a view that they might be for younger applicants, potentially people who are in university at the moment doing their degree. And traineeships, again, most certainly much more diverse than they used to be. And I know that a lot of firms do take prospective employees who have more experience, who may have worked potentially earlier as well. And I think if you said you've already worked on arbitration in Dubai, or more generally, that could potentially be a good route for you as well. However, I don't know if this would be an option available to you, but if you were able to do the QLTS conversion course from a qualification as a qualified lawyer somewhere else to become a qualified lawyer here, then potentially that could be a shortcut for you to be able to work as a lawyer straight away and not to have to do the trainee program, which would involve working in lots of different areas. Whereas if you have your heart set on dispute resolution and arbitration, then you might be able to qualify as an English lawyer and go straight into a dispute resolution position in the United Kingdom.
Hello.
Yeah, I agree with that entirely. I don't know of any trainees who were previously qualified somewhere else. Maybe that has been the case, but it would be a step backwards, I think, for you. But then, of course, the difficulty is getting into a firm as associate. Try the QLTS. Bear in mind, like I say, there are some firms where foreign lawyers work quite happily in this country without qualifying as an English lawyer. You know, generally those will be firms with lots of foreign officers who do predominantly international work. So, you know, that's something for you to find out.
Yeah. Hello. Hello.
Yes, hello?
I don't know, suddenly there's Hello. Hello.
Yes, hello.
Yeah, the network's become really poor suddenly. So, yeah.
Hello, Komudinia. Did anyone hear the question? If not, please repeat it.
Hello. So yeah, I understand. With this kind of a position, it becomes probably a little difficult to break through into any law firm. But yeah, so so you think do you think probably paralegaling would be a way to get in any of the law firms? But what I understand also when I speak to a lot of other people from various law firms, they see it as, they say it probably would show as a sign of desperation in your CV because you've already worked in arbitration in Dubai for a certain period of time. And then when you're doing your LLM, you're also paralegaling. It might just not reflect in the right way as you would probably want to project it in your CV.
I mean, yes, certainly if that could potentially be an issue, but I really think it's about your desire, what you want to do, and then how you portray what you've been doing as well. So if you were to take paralegal work, get some good experience, and then you were to go to an interview and to let them know about that experience that you've been getting and put it forward in a confident and enthusiastic way, I don't see how that could be seen potentially to your detriment.
Okay.
Definitely what James said about going into an international firm and working with your qualification. I mean, I completely agree with that as well. I've sat with lawyers many times who aren't qualified in England and Wales, but we've been working together on cases in multiple jurisdictions, and that's definitely a possibility and one that you should look into.
Can I just add something on that question? I think the thing that you should be more concerned about is having lots of work on your CV, not exactly what kind of work it is. I mean, I wouldn't necessarily go and work in a coffee shop, but again, if there's no alternative, do that, because looking like you're hardworking is more important, and you shouldn't be proud. Shouldn't be too proud about, you know, what you're doing. I didn't go through this, but I had to work as a locum solicitor for a while, just take jobs as they came along in order to keep my hand in, and just, like I said before, just work at everything as hard as you can,
Right,
no matter what it is.
Right. So basically, I have received both kind of views on this. There have been barristers who said that it actually reflects very positively in your CV that you still connected with the kind of work you've been doing. And yeah, there are other people who actually told me not to mention in the CV and probably try to do this for extra money and just, you know, like not mention it in the CV. So I'm pretty confused about whether, I mean, what should the take really be? But yeah.
I think you may have got some bad advice on that second point, if I'm honest. You know, I wouldn't like to, you know, leaving things off your CV. If it's legal work experience, it needs to stay on the CV.
Okay. Yeah, thank you for that.
Thank you very much, Kumudini, and thank you, James and Ben. We have one more question from Edward.
Yes, thank you. I have actually a question for both Ben and James. You said that you worked both as a solicitor at your firm. Is it is it only ADR work that you are doing at this moment? And in which role do you do that? Is it as a negotiating party for, like James mentioned, a firm, a certain firm, or is it really as a mediator or an arbitrator? And maybe also, which one of the three do you prefer yourself?
So I do both dispute resolution and I suppose what you would call alternate dispute resolution. And it's acting for the clients directly and representing them in courts and tribunals. We work alongside other firms. I've done two pieces of mediation. It's not something that you would necessarily find happening in very large disputes, which may not be a very good thing. I think the reason it doesn't is because people like more business people and governments like a little bit more certainty. And often they feel like they may be ambushed in a mediation, which I don't think is correct, but I have heard them say that. They would like a more certainty in outcome, often when the stakes are so high. But I think that's incorrect, and I think there's a lot of pre-dispute mediation that can and should be done. But it's just difficult often to convince your clients to do that.
And certainly, in terms of work plan, been working on litigation, arbitration, and mediation as well. I suppose same as James, less mediation than the other two, but I did lead a mediation quite some couple of years ago, and in fact one of my most recent cases is due to go to mediation in January. There's certainly a precedent by the CPR where they are looking for cases to go to mediate as often as possible to try and solve the differences between the parties before going to court, and obviously cutting down on costs as much as possible. So hopefully it will be something that will increase in action rather than decrease.
I agree, I'm all for it.
Okay, thank you very much. So it's not the case that there is like a ADR specialist in a big law firm who does nothing but ADR settlements.
There certainly are. There are people that just practice mediation. I know lots of specialist mediators who are very good at what they do, and they will be the go-to person for mediation at their firm. I personally am not that person for my firm.
I agree. There are lots of specialists, but then because we all try and take on as much work as we can, you end up working across the different fields naturally.
Okay, thank you very much.
Thank you very much, everybody. We have just a couple of minutes left, and I'm going to ask you a question that one of our members sent. Does your job that you are doing today meet your expectations that you had as a student? And do you use knowledge that you gained at university in your work today?
Very, very good questions, Nia. I certainly think that no, I didn't personally imagine it would be exactly like this. It is very interesting working on international commercial disputes, especially with the traveling element, getting to go to lots of different countries, interacting with companies and businesses there. And at the same time, in terms of the scope of the work, it's quite extensive. I wouldn't have necessarily thought that would be the case a lot earlier on.
Same basic answer. It's not what I expected, but then I had an open mind, and so I didn't have any very firm idea of what I would end up doing. And obviously, before you've actually worked in a law firm, you don't know what it's like to work in a law firm. So you won't know what it's like. In terms of, and that's a good thing. I think it's good to have experiences, unexpected experiences. In terms of knowledge I've gained from university, yes, of course, some of the more basic legal concepts I did gather at university, but actually it's more about the skills you gather at university. For example, research and writing, those are actually more important, I would say, than any specific knowledge. And often, trainees come in thinking they know everything, and the first thing you say to them is, like, we're starting almost from the beginning now, because things are very different in practice. You've done what you needed to do, and now you move into a completely different mindset. But yeah, so drafting is one of the most important skills for a litigator and other types of lawyer, and you do a lot of writing at university. That's the practice that you should be getting.
Thank you very much, James and Ben. Unfortunately, we have to finish our webinar. I think it was a very fruitful discussion. I'm sure there are more questions to be answered. I would like to thank our participants, panelists, and also our YouTube listeners. Thank you very much, and stay tuned for our next webinar that will be in 2018. Thank you and goodbye.